Be good. I'd like to call the committee of the whole for Tuesday, September 5th, 2017 to order with roll call, please.
Kostler. Here. Kraus.
Here.
McAlpine.
Here.
Betts.
Here.
Weinhammer.
Here.
Cavelli.
Here.
Vicki, would you join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'll now move to the public comment section. I know that had a list here that was kind of flip-flop. Is there anybody here who would like to address the committee of the whole on any village matter? We'll go ahead and close open forum at 6:37. We're going to move right into a discussion on the solicitor's ordinance. Hey, Chief.
Before you, or in your packet anyways, you should have had a amended or proposed amendments to the solicitor's ordinance that I tried to encompass most of what we spoke about and received comments on our last meeting. Some of the things that we did address in your the proposed ordinance would be this is just a change from calling them certificates of registration to permits. So it just, we call them permits anyways, so we might as well just put that in the language of the statute. There was a discussion about the manner in which background investigations were conducted and that we use an application, and we basically accepted the applicant's word for any issues related to disqualifying criteria. We're going to change that to, I did some research with the Bureau of Identification, Illinois State Police. The fingerprint-based checks will cost $27 an applicant. So when we get to the fee, it's been rolled into that as it relates to that $27 to submit their fingerprints. But again, we didn't change the disqualifying criteria for a solicitor. We defined new elements of a permit. The current permit is just a piece of paper that we issue to the individuals, and it really doesn't have anything other than the person's name on it. You'd have to have another secondary identification or piece of identification that would indicate that that certificate went with that individual. We're going to be issuing permits that are basically ID cards with a photo on them and some other elements of that permit that would indicate the company that they're soliciting for. Our logo with the Village of Cary, the expiration date of the permit that was issued, and the individual's name. So that'll be prominent, and they'll be required to display that prominently when they're going around doing their solicitations. Signing a $50 per month fee for a permit. Our permits are issued on a monthly basis, and we title letters and things of that nature. And the issue really is that it just has to convey that I don't want a solicitor coming to my door, and it doesn't have to have letters that are, you know, 3/4 of an inch high and in whatever font they're in. So we'll do that. What it doesn't require is individual permits to be issued to groups like Misericordia, where they're soliciting on the roadways, or if the individuals are soliciting it like at a private piece of property that's not a resident, like the Jewel or the Walgreens or a Cary restaurant. If the private property owner allows someone to solicit, they have to still register, but they wouldn't get individual permits for that. And then we'll have to acquire basically a printer that will print these ID, the badges for us. And Public Works happens to have a very a ID printer, so we're going to buy the same printer and use the same process so that we kind of back up each other and we don't have to duplicate our efforts as it relates to supplies for those printers. So some of the, any questions in regards or any comments as it relates to those changes that have been made so far? And that proposed amendment, the strikeouts are what's there and we're eliminating. The underlines are the new language that would be incorporated into a new ordinance.
Just for clarification, a politician, let's say going door to door, not a solicitor, was the politician ever a solicitor?
No, and that's protected speech, and I would defer to my colleague in the legal field
So we don't have
as
to
it
worry
relates
about
to
that issue with
political.
this.
But we can talk about that, because that was the two things I wanted to talk about, was other speech. Because in some communities that I've, and it was a good segue, so, and we had nothing to do with that, by the way. But some communities would say that those people engaged in political speech, religious speech, don't have to register, but would still have to abide by the signs that are posted on the residence. So if it said no soliciting, that would be, that those individuals that are engaged in that type of activity would not be invited on their property. That's something we should discuss. The second thing that we should still discuss, and I've seen it a couple different ways, and I just was curious about the board's desires as it relates to this, is solicitation by youth groups that are not-for-profit, charitable, things of that nature, and restrictions that you would want to see or not want to see as it relates to those types of groups. And what I have seen in my research is a blanket exemption for youth groups 17 and under, 18 and under, that are soliciting for charitable or not-for-profit. And I've also seen it where they don't have that restriction necessarily, but they restrict it to one day of the year. So if a youth group was going to do their annual fundraising activity, they would have to basically contact us, and we'd assign one day that they could do their door-to-door solicitations at. So I've seen that that way. So there's a number, there's a number of different ways we can restrict it. So again, first thing is minors and how you would like to see that addressed.
I've never had an issue with solicitors in the past, and I think I'm not in favor of changing the code, what we have currently.
I'm not in favor of restrictions on minors, and at the risk of everybody showing up at my door, I've never turned one down. They show up, so I buy, but yeah, that's fine with me.
Chief, before we go on, Trustee Cavelli, could you rephrase your question so Attorney Chapman?
Were you talking about how,
Somebody campaigning, let's say, going door to door. This policy, the way I read it, would not impede that person from going door to door.
that's correct. The way that it's the definition of soliciting, it's soliciting for a business or a charitable organization, so some kind of a nonprofit, or selling newspapers or magazines and that sort of thing. Political speech does not fall within solicitation and wouldn't be regulated.
Okay.
I
That's
did
the
want
way
to
I read it. I
address.
just wanted to clarify.
Yeah, I did want to address the minor issue because I'm aware of a lot of communities that do that too.
Right.
And they treat different groups differently.
different.
But
It's
very
difficult,
recently,
yeah.
the Seventh Circuit, which is the Court of Appeals that is over Illinois and the Midwest, ruled that, and they struck down a Springfield, was a panhandling ordinance, so a little bit different. But the language in the opinion was basically that you can't, they were prohibiting panhandling within a certain district and in a certain manner. So certain kinds of speech was okay, but not others. And the court said you can't pick and choose what type of solicitation you're going to ban or you're going to restrict or regulate. It's a little different for political speech because that's protected under the Constitution. But I would be careful, and I know a lot of communities do it, but this is a very recent decision. It was last year. And I would suspect that some of them will have to amend to not treat different groups differently. So if you're going to require a permit, unless it's constitutional speech, that everybody follows the same rules. So whether it's a youth group or some other group.
So what you're saying then, just to make sure everyone's in agreement with this, so what you would say is, you're saying that if it is a youth group, they would need to go through the permit process, pay $50, and go through the same thing as everyone else did, so that we are treating everybody equitably.
Yeah. And that's what again, pre-last year, I know a lot of communities do this. They have different levels of, try the Boy Scouts or the whoever, to make it a little easier on them. And it makes sense, but I think that if it were challenged, that based on the Seventh Circuit opinion, that it would be struck down. So, because it's based on the message, and the message being, it's being delivered by certain people. Same thing if you said, I want to ban soliciting within a certain area of the community, and you can't do that either.
Now, what I have seen and what worked very well that I thought, it was, this is my opinion, so I'm going to give that caveat, is that we do have an exemption for those permits being issued to the individual if people are going to a private piece of property, and I'm going to use the Girl Scouts because it was a Girl Scout tent that was set up at one of the schools, and it was basically a drive-through, and it worked real well. So, instead of going door to door, maybe they set up someplace in a parking lot and kind of have a drive-through, and I think that works as well or better than people going door to door. And again, it's really a policy decision. It's not
Can I ask you a
chief police
question?
decision.
How many problems, have you seen any problems? And the reason I bring this up to you is that you didn't bring this to the board, so I'm not sure, do you see problems with solicitation? Are we having a lot of issues with how we're currently set up?
We have a lot of solicitors, and we try to stay on top of solicitors, especially when we see them come in for certain reasons.
Right.
They come in
The
in a big
utilities.
group. Yeah, exactly. And then what we'll do, the village administrator and myself, is we'll usually put something in the News Weekly that says something to the effect of, these are how solicitors should act, or this is how they should act. We would never address an individual company and indicate that, they're soliciting, because that would be unethical. But we can certainly remind people that they have the right to tell people not to come to their door, or to leave when you tell them to leave, or to affix a no solicitor sign to your door. And if they come to your door, they're in violation of that portion of the village ordinance. And I will tell you that the stickers have been flying off the shelves since we've been talking about this.
Well, but they're in violation if they ring your doorbell. They're not in violation if they walk up to your door because they have to see
No,
the sign.
That's correct.
Okay, just to
Yeah.
make that clear.
Yeah.
So someone
No.
coming on your property is not in violation.
No,
Okay.
you're exactly correct. And that would be for your principal residence entrance.
Sure.
So, for everyone else, it's the front door, right?
Exactly.
So, and again, maybe that's how we address the minor issue, is we say, this is how we suggest that we do it, or we don't address that at all and make them go through the process.
I think it's still good. I mean, it's healthy to have discussions here about our ordinances. I mean, we don't always look at these ordinances all the time, and so it's good to talk about it as a group here to see where we can improve, or certain things we may want to consider or add to improve our ordinances.
The other thing I can't control, and that is solicitations for publications like newspapers, magazines, and things of that nature, that's specifically exempted in our current ordinance. And going back, I found Thomas G. Osborne versus the Village of River Forest in 1961, where they addressed this issue, and it seems to have stood. So that seems to be the controlling case in regards to that.
Julie, I have a question, considering the minor issue. How, if we have to treat everybody the same, how can we have a minor apply for a permit when they're not an adult? So how does that work?
Yeah, I've seen it, and I think that there's language in the proposal to deal with if it's on a private business site. So if they go to Jewel and that they don't, each individual kid or solicitor doesn't need their own individual ID, that it would be operated under a general certificate. And I've seen communities that have done that so that instead of, if there's a group that continuously has certain fundraising events, that you could, instead of saying every single event is one event, that they would come and apply once as a group. And that's just something to think about. But you couldn't say only the Boy Scouts could do that, but not other groups. Once you allow that, you would say one organization could register and list, we're going to do these fundraising events. And then that you would have a responsible person that signs. And especially with minors, you wouldn't be issuing, but it would be the same for that, for other groups. If they applied for a certificate as an organization, then any of the people that solicited would be under the same certificate. So that way you wouldn't be treating them differently, but it would cover that concern.
And from my standpoint, there's somebody to contact in regards to the conduct of the solicitor, and then I could revoke that certificate, which I've only done twice since I've been here, and it was for violations of the solicitor's ordinance, our individual solicitor's ordinance.
So one of the things that I asked about, and I brought this up, was, what about a young entrepreneur? I don't know growing up, but we went around and we shoveled driveways, or we wanted to mow lawns, and you throw out a little flyer. So they would have to get a permit to do that, in other words.
They're not a group.
Because they're not a group, it's an individual.
Well, they're providing a service
They're
at that time.
providing a service to get paid.
Yeah, but
Dog-
if they're
dog
putting,
walking
if they're
walkers.
simply
Yeah, it
just
is.
putting a
Could-
flyer,
One
No,
person
they
talking.
wouldn't.
then you don't need it.
Yeah. You wouldn't, at least my interpretation of
Me
this
too.
is that you wouldn't need it for that.
Okay.
If you were, that's a good, because I have to look at our the definition, but that's a service. Okay, it says services in here, so seeking services. So yeah, I guess that would technically apply in regards to snow, removing snow, mowing lawns.
Babysitting, dog walking.
I don't know if you solicit babysit, maybe, but it's usually something
I've gotten
you do
it before.
neighbor to neighbor, but
Yeah. I'm kind of with Jeff on this, and that's that I feel that we don't need to do something more. I think we need to educate, that it's really as you said, people are coming and getting those no solicitors. I think that's huge, that people should have that opportunity to put that up there and say, I don't want a solicitor in here. But if you're not really having issues with it, I'm not sure why we want to make more work.
no, I didn't say we weren't having issues. I think people do call us on solicitor issues. But again, regardless of what we do here, I'm going to probably amend the way that we issue the
Sure.
permits, because I think that was something in our discussions here
Yep.
that we could probably do better, right? And the fee is probably something that we're going to have to talk about, because I think when we started talking about this, and we do something rudimentary, we make sure that there's no warrants for them. We make sure that we can identify who this person is, but really that's the extent of it, and then we take them for face value as it relates to disqualifying criteria, which are felony convictions within the last 5 years, by the way, and then any violations of the solicitor ordinance here or in other municipalities. And now my research has led me to counties can do it now. So Lake County just recently enacted an ordinance as it related to solicitation. So, that's, there might be some things that we can tweak to make better. And maybe the fee is something that we want to talk about if we're not, concerned about, those types of issues related to, other language that we've changed here. But, or do we just leave it alone and make them give us a picture so we can at least identify the individual? Because what we do have is we will have people that don't register,
Right.
and they have to register with us. If they don't register with us and they don't fall into an exemption, then we have to go find them. So that's probably the biggest issue that we have as it relates to solicitors, or the solicitors that come in that we really can't regulate, and that is, soliciting periodicals, publications, And, but they're still bound by the issue related to the empowerment of the resident, and that is no soliciting. So you put that sign up, if they violate that, they're still in violation regardless of if they registered with us.
This seems like it's going to be more and more burdensome. There's so many ifs, ands, or buts about this that, how are you going to be able to enforce this effectively? And is the $50 fee that is being presented here, is that going to cover all of our costs? You've got name tags, badges, whose
right
time is going to be taken up?
It would be records, and actually, Deputy Chief Biltmore is going to be responsible for the administration of this, so.
But
I just think
there's a
something-
current process that is being done now, and-
Sure.
and nothing's being charged for staff time. I
Correct.
like the fact that backgrounds are being done. I like the reduction in hours. I think that that's great. Feedback I've gotten from residents is very overwhelmingly, they do not like solicitors at their doors. So I like it as is. I think it's really good, actually.
I don't know why you wouldn't want somebody to be able to be identified if they have a permit. Before, we talked about people being able to just claim that they're somebody else. I think it's good to have a picture with it. I had a question for Julie. I know Ellen kind of touched on it. So with regard to the youth, we don't have a choice. Like, we can't, was that something that was done a year ago with another court or case law or something like that, where youth is required to get a permit?
They're not required to get a permit. Nobody is under state law. It's only you that decides whether you want to require a permit for solicitors. When you do that, you can't treat groups that solicit differently unless there's some protection under the Constitution. So the village doesn't have to require permits, but once you choose to do that, then you have to treat everybody the same. So you can't say, these people have to get permits and this type of solicitation requires a permit and this kind doesn't. The problem is discriminating between types of solicitors, not that minors have to get permits. Once you have a permit requirement, you just need to treat everybody similar.
I have no problem with what's written up, but I do have a problem with the amount that I really would like to see, the fee. I'd like the fee to be raised and make it harder for a person who has a problem, or, who let them pay that fee.
I'd be okay with that, too.
Yeah, I agree with that as well.
So I'd say keep this as it was, but just let's raise the fee.
No, I'm just saying I agree with the fee being raised and not keep it as it was.
So,
I like the restriction of the time. I think that we should make them pay for the background check and their permit fee separately. As Chris said, I'd like to have the cost increased. And as I already said, the shortened time to 6 PM would be great.
Yeah.
Any other thoughts down here?
I like we did, Chief. I think it's good, and I'm open to raising the fee as well, if that's what the majority of the board wants.
Okay.
What fee are you talking about? What would you like it to see? It's being proposed at $50. Would you like it?
I don't have that came from that side of
I
the board.
would
so-
say like $500.
Oh,
I don't have a problem with that. I actually like that because it
That's going to be a problem.
defers people from coming. I mean, you guys asked on your Facebook page, and in an hour you had, 100 and some answers on, how people felt about solicitors. And so, I mean, if we're taking into consideration feedback, and it's only on Facebook feedback, so it's not, accurate representation of the whole town. But if we're taking feedback from solicitors and things like that, I think we should make some changes. I think we should make it harder for them.
I just addressed the fee issue. To qualify as a fee, it has to relate to the administrative costs and enforcement costs. So unless the chief could show that it costs the village $500 every time somebody applies for a permit, then it's considered a tax. And we don't have taxing authority except what's set out in state statute. So the fee needs to relate to the costs of the program, or less, but it can't exceed it because then it's a revenue generator and it's considered a tax. So Chief, you may have an idea of administrative costs, printing out the IDs,
Sure.
those sorts of things that if you looked at the program as a whole and divided it by what solicitors are out there, what would the fee be that would?
Right, and the background investigation or submission alone was $27. So now we're down to 23, and then we're a couple dollars for the ID, and then we have to buy a printer, which is about $897, $900, and then our time to process it. So anywhere between $50 and $75 is probably an okay justification as it relates to, the time as it relates to processing our supplies and buying new equipment.
I have a question, Julie. So I'm looking for my email, but I can't find it right now, but I had copied the board and yourself on it with examples from other towns that had gone ahead and imposed fees. And I think maybe that's where Chris was getting her idea, maybe not, but about the $500. Because there are some towns that have implemented really high fees like that. So is that something new where they can't impose high fees?
No, the law on fees and taxes has been around for non-home rule municipalities for as long as I can remember. Some of those communities might be home rule. They have higher authority to tax, so they could actually impose a solicitor's tax if they wanted to, as opposed to a fee. But same with building permit fees and other fees. If you're going to impose a fee, it has to relate to the administrative and enforcement costs. Now, administrative costs may be 50 to 75. If the chief has to do a lot of enforcement, like we do in liquor fees are higher because it's not just administering the program, but the enforcement of liquor establishments is actually very costly if solicitors have the same thing. So those communities, they may be home rule or they may have done a study. If we can do a study and justify a $500 fee that it relates to the cost of the program, then we could impose it. If we don't, and it's intended either to generate revenue or as a punishment or a penalty or a discouragement, then it's considered a tax, and we just don't have that authority.
I think the $500 is probably getting a little bit high, but the chief and I can go back and we can look at it and account for all the staff time associated with this and come back with a number here. It sounds like the village board is mostly supportive of bringing back some kind of ordinance with an increase in fee. So maybe we could go back, do some assessment here and bring back an ordinance for the village board to consider.
So you have the information that you need to clean this up to bring it back as an ordinance?
I just want to comment on the fee because Chris, when you brought up that you had an issue with the fee, I was hoping you were going to go in the opposite direction because I think $50 is kind of steep to begin with. I mean, there's somebody out there, maybe they're selling a lawn care service, so they need to apply for a permit. Maybe $50 is what they make. That's their pay for the day. And now I just...
It's $50 for a month.
For a month, okay.
Yeah, it's $50 a month, but again, it's $600 a year if you do it every month. And we do have a couple of individuals that do routinely receive permits, but then we have other groups that come and go.
Well, with regard to that comment, I just want to make sure, we're here to look out for the residents, not to look out for the solicitors. So I'm looking out for the residents instead of the
I
solicitors.
think I'm looking out for the residents too, Jennifer,
I'm not
okay?
trying
Okay,
to be
all
rude,
right.
Jeff.
Well, the only comment would be that some of our residents could be solicitors. So keeping that in mind too, that my only hurdle that I have with this is little startup, kids trying to do things that I think that there could be unintended consequences when we put something like this in as to how it's going to impact, when you're trying to get your kid, hey, get out there, get that spirit, get out and do something. I don't want to, that's my only concern with it. Other than that, I think it's very well researched and written, and I understand the whole complexity of what we're looking at.
I think too, to that point, we can certainly look at other options here within the ordinance. I think it was mentioned earlier by one of the trustees about putting up flyers, things like that are within people's rights here where, as long as trustees have that information, you can provide that to residents too.
one last question. Kind of asked it before. I had a resident email me and ask if people can put flyers on their mailboxes. Is that allowed or no?
Well,
Or on.
we don't necessarily do that. That would be more of a building and zoning issue or a postal issue. I will tell you that they don't like them in the mailboxes.
That's a federal crime.
Sometimes that they'll put secondary boxes on the posts for like newspapers and things of that nature. I will tell you that people don't like it, my wife being one of them, when they throw things in plastic bags and a rock and a piece of paper advertising their business. Exactly.
I think when we looked at it from a code standpoint, community development they had to be attached securely to
Okay.
the residents.
So
that
the
they
mailbox
wouldn't-
was okay
So
if it
that
was
they wouldn't
attached
fly away.
securely?
Can't go
It
inside.
can't, yeah, it can't go in, but somewhere on the premises, it's got to be attached.
Yeah, but I guess firmly affixed.
Correct. Yeah,
So-
we frown upon it a lot because typically what happens then is it blows away and it becomes litter in that case.
And if they do it in the metro lot, people just throw it off of their car and we end up having to clean up. So, not us, but Public Works generally.
Okay, you have the information that you need to bring this
Yeah,
back?
I think so.
yeah. Yep.
Thanks,
Chief.
Thank you.
Thank you.
Okay, moving on to discussion regarding conflict of interest and ethics policy.
Yeah, thank you, Mayor. The village attorney here is going to go over this evening, kind of set the table for the village board about the baseline of where we're at currently as far as our local ordinance, which is essentially the state statute. What I want to provide, because we've had several discussions here with the village board members about potentially having a ethics policy, is I want to give the baseline and have Attorney Tappendorf kind of set the table here so that we can decide if we want to go above what the state statute is, or if we're comfortable with staying with the state statute as our local ordinance. So I'll turn it over to Attorney Tappendorf, and we'll be happy to answer any questions that the board has.
Okay, thanks, Jake. So I just want to go through, and obviously I'm not going to go through every single statute. It's 50-plus pages in the, both in the Illinois Municipal Code and in the State Officials and Employees Ethics Act. But I want to touch on all of the various ethics, and these are state laws that apply to elected officials, so everybody here, and some appointed officials and some employees as well, depending on the law. So the first one I want to mention is the Gift Ban Act. This actually came up at the last meeting I was at, and there was a question about if a prohibited source, so somebody that does business with the village, gives a gift to an official, does that violate state law? Does it create some kind of a conflict? And there is a state gift ban act, and it's been incorporated by reference into the local ordinance without any changes, that does prohibit, it prohibits the elected official or appointed official or employee from accepting a gift from a prohibited source, and it prohibits the prohibited source from giving the gift. So it's two-way prohibition. And a prohibited source would be, and it's defined in the statute in a certain way, but generally somebody that does business with the municipality, has contracts with the municipality, is seeking to do business. So maybe a developer or a retail business or somebody like that. There are 12 exceptions that are set out in state statute, and that's in the outline. Just kind of as a general rule, if it is, let's say that a business gives a discount to everybody on a Monday, it's 10% off, then you guys can go into that restaurant and get your 10% off because that's offered to everybody. So it's not being offered, it's not a gift to you because of your official position. Anything that you buy at market value, obviously if you go into a store in the community and buy something and you pay full price for it, that's not a gift. Campaign contributions, fundraising contributions, that's not a gift. It's one of the 12 exceptions. Educational missions, so if you go on some kind of government retreat, travel expenses for a meeting to discuss government business, so if the board went on a government retreat, gifts, from relatives, this seems kind of obvious, but if one of your relatives was a business owner in the community that was going to come in for some kind of action, that would be okay for you to accept a gift from them, even though they are a prohibited source, because it's not on the basis of your business, it's on the basis of your relation, and the same with a personal friendship. So if you have a personal friendship with somebody that you have a relationship that you give, then even if they're a prohibited source, that's okay. Then there are a couple of what are considered the most common exceptions that I see in with my clients, and that's food or refreshments not exceeding $75 per person per day. That allows a prohibited source for you to go out to dinner or a drink or a game if it was, golf if it was less than $75, to have food. It has to be consumed on the premises or catered. That means you're going to a restaurant or somebody is bringing food maybe to Village Hall, that's an exception. If it results from your outside business, then it's exempt. That makes sense, even if they're a prohibited source, but there's a gift given that has nothing to do with your position here, because that's the whole point of the Gift Ban Act, that people aren't giving you gifts to try to get something from you, some kind of an action. Intra-office, inter-office gifts. And then the last one is sort of a catch-all that a prohibited source could give you gifts of value of less than $100 in 1 year. And so you might get, if you have a consulting engineer or an IT group that you consult with and they send cookies or popcorn at the holidays, that would be less than $100, that there's no violation of the Gift Ban Act for that. Used to exempt golf. That was a big thing for the state legislators to have in the exemption. Troublesome to residents, so the golf exemption is gone, but if it fits within the $100, you're okay. So what does that mean? There are a lot of exceptions, but there are bans on accepting gifts from prohibited sources. If that happens and say it's over $100 or it doesn't fall within one of the other exceptions, you could pay for it, you could return it, or you could donate the gift or the value of the gift to charity, and then it's not a violation of the Gift Ban Act. Any questions on the Gift Ban Act? It's usually pretty straightforward. Prohibited political activities, that's another section of your local ethics ordinance where your local code has just incorporated the state statute. So just basically not made it any stricter, it's incorporated the state prohibitions. The Prohibited Political Activities Act, in a nutshell, you're not supposed to use village resources, village money, village time, so village staff time, employee time, to run for office, to campaign for somebody, either yourself or somebody else, or for a referendum question. And that's really what it is. So it's a very long statute. There are tons of language about what you can and can't do. But really the main point is you're not printing off political leaflets using the village copier. You're not asking staff to go out and get signatures to run for office. We're not using village resources to advocate for a referendum. You can provide factual information. You can't send out, vote yes, because, and schools see this a lot more because they go out for more referenda, that there are just rules in place to not tie up village resources and village money and village property for political campaigning. So that's kind of, it's a couple of pages in here, but.
I have a question on that.
Yeah.
Just a total hypothetical. If there was somebody running for office in Cary and they brought in campaign photographers to the Village Hall to take pictures in Village Hall, is that illegal?
Well, was somebody on their compensated time? Were they using village resources? I mean, some of it would depend on, were village staff there on their compensated time to use it? Do we allow other people in the Village Hall? Because sometimes you'll have people come in and take, it's a public building, so to have pictures taken, I probably need a little more facts to look at, was it use of actual village resources, time, money, or was it just use of public property? So that I would say it depends on maybe a little more facts on that one.
Okay.
Let's see, any other questions on prohibited political activities? The next is disclosure of economic interest, and a lot of this is just background information. You guys have all done this because you ran for office. So when you run for office, you have to file your disclosure of economic interest, the statement of economic interest. It's just a form that is required when you campaign. And then once you're in office, you have to file it once a year. And you're just basically disclosing your other employment or financial interests. So, everybody here, certain appointed officers and certain employees have to file these statements of economic interest with the county. And it's, again, once a year.
Julie, can I ask a question on that? So should all of us who have income fill something out that says, like, our employer name, or can we leave it blank, or can you just tell me more about that?
Yeah, the form, the only things you have to disclose are the answers to the questions on the form. So the form will set out what you have to disclose. It's not everything. So it's not everything that you do. It's specifics, just kind of examples. If you are an officer, director, associate, partner, or proprietor. So if you're an owner of a professional organization or practice, let's see, professional services. So nature of professional services, nature of the entity, if the fees exceeded $5,000. It's not usually related to your other job. It's more related to ownership interests or financial interests that may have some relationship with the village. I mean, I've seen a lot of these, and most of them, maybe 2/3, 3/4 of them, it's NA, NA, NA throughout. There aren't that many disclosures that would apply to any of you. I see more on the state legislator disclosures that there's usually more going on. So, if you're doing it in your campaign, I would suggest working with, if you have an attorney who kind of assists you with your paperwork to make sure that you are disclosing what you need. As an elected official, you could probably ask staff, because now it's a disclosure, not as a candidate, which the village could not help you with, but a disclosure as an elected official. So
It's safe for me to just put nothing on there as an elected official when I fill it out every year then?
I don't know, because I don't know your interests. So, I've seen a lot of them where there's nothing on there, but I couldn't advise you what to respond without knowing the answers to each one of the questions. You've got to go through each one of them and know whether or not you have some disclosure.
Those will get sent out to trustees, I think, later this year.
For May.
Early next year, and I can help with any
Yeah.
questions that you may have.
Okay.
So.
The next section is conflicts of interest, and the first piece that I wanted to mention was holding other offices. This doesn't come up a lot, but every so often we'll get questions from trustees or other officials. Can I hold this other office? Is it a conflict to be on a school board and be on a village board, or I want to run for some other office? Can I do both? That sort of thing. It's fairly strict for village board members. I mean, there are 2 statutes that talk about incompatibility with offices. Most of them relate to holding another office here in the village, so having 2 incompatible offices, which makes sense. So you can't, as a village board member, trustee, or mayor, also serve on the ZPA. And that makes sense because it would be an office that would be appointed by the mayor and with the advice and consent of all of you, and you'd be serving in 2 incompatible offices.
And just to clarify, that's the Board of Zoning, Planning, and Appeals.
Yeah. So it talks about, under the one of the statutes, that a trustee cannot be appointed to any office that would be appointed by the village president. And that's an office, not a committee. Committees are different, they're not offices. The ZPA is an office, so you couldn't be on both of those. It also, there's a statute under the Illinois Municipal Code that president, trustee, clerk, or treasurer cannot hold any other office in the municipality unless you get a leave of absence. So if you wanted to serve on the police commission or some other office, you'd have to step down as trustee to be appointed to that office. There are exceptions. The one is that the mayor can be the local liquor commissioner. That is by statute. In fact, that's statutorily mandated that the mayor serves as the liquor commissioner. A clerk can also be the village collector, and any one of you can be a volunteer firefighter. Those are three just statutory exceptions to not holding two offices in the same community. There are also many incompatible offices even outside of the village. So school board is one. Village trustee cannot also be on the school board. Those are considered incompatible offices. If you ever had a question, I mean, we could go through, there would be hundreds and hundreds of situations that could come up. If you ever had a question, you'd ask Jake, he'd consult with me. There's a guide index from the Attorney General of incompatible offices that we check, that's published, that just says, okay, here's trustee and here are the offices that you can't hold while you're a trustee. So the next is Prohibited Political Activities Act, and this is the general conflict of interest rule. And we talked about this, actually I did a memo on this. We talked about it a little bit, and we talked about having a more broad discussion about it. This statute and the Illinois Municipal Code, which really the language is very similar, and the cases are, they hold the same. This is the statute that says that it's a general rule that a government officer, so a municipal officer, cannot be financially interested in a contract or business that the officer would have to act or vote on. So being an owner in a company that's coming before the village board to approve a contract for that consulting services with that if you're the owner of the company, you're going to be financially interested in that decision. Whether the company is an LLC or a sole proprietorship, or the contract's in your name, that you get a financial interest. So the general rule is if there's some financial benefit going to you from a contract or some kind of business, that you cannot participate in that. There are a lot of cases, and I cited these. We don't have to go through all of them, but there were some examples of how the courts interpret what a financial interest is. The courts look at whether there is self-dealing bordering on fraud. Really, the whole point of this is, are you as a board member conflicted in voting on something that you are going to get some kind of self-dealing from? So you're trying to approve a contract or some kind of business that's actually going to financially benefit you. And it doesn't have to be a financial benefit under both of the statutes that have implications for municipal officers. Let's see. There are a lot of exceptions under both statutes for certain small contracts. As an example, I had a community where one of the trustees had a flower business. It was the only flower business in this very small downstate town. And whenever there was a funeral or something, the board wanted to order the flowers locally, but this trustee was the owner. There is an exception for very small contracts. In this case, if it was less, $2,000 or less, or $4,000 for the whole year, where the board could approve that contract, even though the board member was an owner of that company, but the trustee could not vote on that. So that was, it wasn't that the board couldn't contract with that flower shop and give that example, but it had to fall within the very small nature of that kind of a contract. There are some exceptions for minor interests. If you are an owner, a very minor interest, say you have mutual funds in a company that, maybe you have mutual funds that own AT&T stock, and AT&T comes in with a cell lease. So you're approving a cellular lease. Clearly, that's a contract that's going to financially benefit AT&T. The fact that you have mutual funds or you even stock, if it's such a small portion, which great if it wasn't, but it probably is, that would not disqualify you from voting on that. Service on a nonprofit board, we have talked about that. There is an exception that allows somebody to even be financially interested in on the nonprofit board and in a contract or business before the board. If they have a financial interest, they would have to recuse themselves. There is an attorney general opinion that says that if there's no financial interest, so if you're not compensated by the nonprofit, then it's not a conflict of interest at all. It doesn't fall within that. So this exception applies. If there's a financial interest, you would have to recuse yourself. So if you are compensated.
I just have a question on that, Julie.
Yeah.
Because, and I've brought this up before, but the paragraph F says voting on any matter. Doesn't say anything about a financial interest. So
It's F is under the or under the umbrella of the conflict of interest statute. And the court cases are very clear that to be a statutory conflict of interest, there has to be a financial interest. That is all of that section of, I guess it's, let me find the site, 105-3, that conflict of interest statute under the Public Officer Prohibited Activities Act. I know we've talked about this quite a bit, but the Attorney General has said that it is not a conflict of interest to serve, if you are not compensated, to serve on a nonprofit board. This statute applies to a financial interest. So let's say you are compensated by that nonprofit. So maybe you're paid, maybe you get a stipend, maybe you get discount, whatever it is, that you're not disqualified and the board can still approve the contract, but in that case, you would recuse yourself. So it's two different situations. If you're compensated, it falls under this, you recuse yourself. If you're not compensated, the Attorney General opinion just says it's not a conflict of interest. It doesn't fall within the statutory conflicts of interest.
okay. I don't agree with you on that point, and I've made that clear in past emails, and I just need it on record that this has nothing to do with financial interest. It stands alone, paragraph F, and it's very clear. Your Attorney General opinion is from 1975, I think, and paragraph F wasn't written until 2009. And there is no case law on it. I agree on that point, but I think it's pretty clear that it stands alone and it doesn't have anything to do with financial interest. That's just my opinion.
Okay.
So.
Anything else on the conflicts of interest? The next, page 12, I just cited the municipal code conflict of interest, which is very similar language, financial interests. There's also a provision about purchase of property that is added to the municipal conflict of interest. So this would apply to municipalities. That you as a municipal officer cannot have an interest in the purchase of property, and this is that belongs to the municipality, is sold for taxes or assessments, or is sold by virtue of legal process. So if the village, if a property went into tax sale and there were taxes owed to the municipality, which there would be as part of the taxes, that you cannot have any interest in buying that property. So it's just something that only applies to municipal officers. Let's see. Common law conflicts of interest. The case law, it used to be, before there was a statute on conflicts of interest, that all conflicts of interest were under common law, and that just means that they were developed by courts, so by case law. That since, and the courts all agree with this, that since these conflicts of interest have been codified, in other words, they're now in state statute, in two different statutes, that the common law conflict of interest has been codified, and that in essence, a common law conflict of interest is the same type of pecuniary or financial interest that state law talks about, that we've talked about. The standards that the courts apply are the same. This is different than what we talked about before about having an appearance of impropriety where somebody, where there's a perceived conflict, but it doesn't qualify as a statutory or common law. But the standards for the common law that are applied, at least by the courts, are the same, and the Attorney General are the same as under the statute. Now, an appearance of impropriety, and this went into my previous memo, is really where there isn't a statutory conflict that disqualifies you from either participating or disqualifies the board from even entering into a contract or approving business. So putting that aside, there still could be a perceived conflict, an appearance of impropriety, where your loyalties might be divided, where you cannot be impartial or biased. We see this a little more in zoning and planning decisions. In fact, I've done a lot of trainings for zoning boards about bias because they're quasi-judicial. They act almost like a jury or a judge when they have a public hearing, and both the residents and the applicant have due process rights, and they have a statutory right to an impartial and unbiased hearing body. So we see that a lot more, this appearance of impropriety or this impartiality issue when we have hearings. But we could have that here too with hearings. Really, what this appearance of impropriety means is if you as a board member feel that you cannot apply the facts to a particular situation, look at something impartially, unbiased, and vote as a board member to benefit the village board as opposed to benefit some interest of yourself, if there is some interest. What the court says is that you look at it yourself. It's not that the board votes you off. It is your own internal judgment call as to whether you want to abstain or recuse yourself. It's not a statutory mandate that you step out, or that in some cases that the board can't even enter into the contract. But it's if you feel that you cannot be impartial, that you can't vote based on your duties as a village trustee. And I've seen that in communities. Sometimes somebody will recuse themselves because an applicant's coming before them and they know the person really well. Maybe they answered questions about something or they helped them with an item. That's not a statutory conflict of interest that prohibits you from voting. But if you yourself feel you can't be impartial, then you can choose to recuse yourself. It's a little different than a mandatory recusal. And, you know, from a legal perspective, sometimes I get that question, and I will, if somebody asks me, do I have a conflict of interest? Do I have to, you know, recuse myself on this? If it's not a statutory conflict of interest, I would say it's up to you. That's a judgment call you have to make. It's not something that the attorney or somebody else can tell you that you're not impartial, because only you can make that call. The last thing is just, actually, yeah, the last one is official misconduct. This is pretty rare. We've seen a few of these for our governors, but not so much at the local level. But and it's not employed that often. But this would be, and this is a criminal statute. This is in the criminal code. Official misconduct, and it's intentionally or recklessly fails to perform a mandatory duty, so something that you have to do, knowingly performs an act he or she's forbidden by law to perform. If you exceed your authority with the intent to gain some personal advantage, so not inadvertently exceed your authority, adopt an ordinance that you shouldn't have adopted, but you do it so that you can get some kind of personal advantage, or if you solicit or knowingly accept a bribe. So, you know, some kind of money to vote on something. I mean, that's really what it is. That would be official misconduct, that it's a criminal issue. It's not something that would be taken up by the board. That would be something that a state's attorney would look at. And then Jake mentioned at the beginning the local ethics regulations. The only provisions in the local ethics regulations that the village has. It's the Gift Ban Act and prohibited political activities. That doesn't mean that the rest of what I talked about doesn't apply, because it's state law, so it does. But certainly you could choose to go stricter on some of the provisions, adopt other ethic regulations. You got the sample from the Village of Glencoe. They have adopted regulations on family relationships, which are not a conflict of interest in Illinois under state statute. So if your spouse is a prohibited source, or not a prohibited source, but has a relationship or a contract before you, that's not imputed to you. There's no spousal conflict of interest in Illinois. But as an example, that's something that Glencoe has established under their local regulations. So it's not a state conflict of interest, it's a local one. And some of the other things, the private use of public property, no officer or employee shall request or permit the unauthorized use of village-owned vehicles, equipment, materials, or property for personal convenience or profit. That's not under state statute. That's a local regulation that Glencoe, and those are just a couple of examples of some of the things that a local ethics policy might include. That's mine.
So right now, just looking for feedback from the village board regarding if we want to go and be above and beyond, what's in the state statute right now for local ethics ordinance.
Any comments?
Yeah, I would be interested in going above and beyond.
Me too. I agree with Kim.
What would you like to see?
Well, I do like Glencoe's policy. I think it's a good starting point. And, is there any other policies out there that we're aware of?
We could compile some. Most of the ethics rules in codes just mirror state statute. That's pretty standard. I'm sure we could find examples of other communities. I gave this one because this was a pretty comprehensive, so you could kind of pick and choose if there were things that you wanted to incorporate or not incorporate. Again, most of the communities I work with, they may have more than what Cary has in their code, but it's just mirroring state statute, so it's not going
I like
further.
it.
That doesn't mean you can't do
I
it.
think it holds us to a higher standard than what the state allows. And it seems like there's a lot of stuff within the state statute that are a little murky. So I like the Glencoe policy.
I agree with Trustee Cavelli, and, I think this is something we could take a couple weeks, and each board member could do their edits if they want. We could figure out where meeting common ground, but it seems like a good place to start, and, it is more than what the state state codes are right now, but I think we need that here.
I'm comfortable with the state statute.
Trustee Galpin.
I think some of the things in Glencoe, while they may be good, I think some of them are overreaching. So I'm not in support of Glencoe's policy. I think that the state is pretty comprehensive about what's allowed and what isn't allowed. I think that we can incorporate some ethics in some of our other policies. But I'm fine with the current state statute.
I'm fine with the state statute.
I would like to see it tightened up. I think Glencoe has 6,000 residents or something like that. So, when you say that there's a conflict of interest there, for only having a small town and everybody kind of knowing everybody in Glencoe, they have a pretty tight, ethics policy. So I do like having a tighter ethics policy in place. I would like to look at it. I do like Jim's idea of allowing the trustees to have some time to look at it and make some revisions on what they would like to see and what they wouldn't want to see.
Yeah, I tend to agree with, I think I'd like to see what other communities have. Julie, you have some ideas of somewhere to go to look to tighten up some of these things, but this is something that's important, and we need to take our time to make sure that it's done right. Tighten up the loopholes, just to make sure that everybody's on the same page with regards to this. So I would be willing to see what else is out there so that we can make some comparisons and what works. Talk to other municipalities, find out how things work with that too.
So the board would like us to find some examples here and maybe work on just taking an initial shot at a draft policy for us to talk about at a future meeting.
Yeah,
Is
and
that
maybe we
fair?
can highlight that's already in the state statute and what is additional. That would help clarify some comments as well, if everybody's in agreement with that.
Yep.
Yeah, I like it.
Okay. You got your stuff? Next, discussion regarding public comment policy.
Thank you, Mayor. This was an item that was reviewed and considered by the village board, I think back in the October, November timeframe of last year. At that time, there was a motion for the item, but there was not a second, so it failed. We've since had 2 new board members join the village board. So Mayor Koenig has asked this to be considered here by the committee of the whole and ultimately advanced to the village board for future consideration. So happy to answer any questions that the village board may have regarding the public comment policy.
I will certainly, this is something I brought up also, that I definitely felt that should be something we enact. I think it's important that our residents have, from a transparency standpoint, know what to expect when they come before the board, how much time they have to speak, what we're looking for them to do, the procedures that are going to be followed. I think it's a way to make sure that everyone is treated equitably and fairly. And I think it's also a way to protect our board, to make sure that someone doesn't come after, no matter who's sitting on the board, whether it's us or whether it's someone else in the future. I tend to, go with what, the Attorney General has kind of recommended, that everyone should have something like this. So I think that it's, again, the fairness and equity is an issue, and the transparency is why I think it's important for us to have that. I personally know of people that have come before the board and have said to me, what should I expect? How does this work? What's going to happen? It'd be great to be able to have something even on our website that they could click on and say, hey, you're going to come before the board. Here's how the process is going to work. And I think that alleviates some stress when people are coming before us, but it also sets boundaries and guidelines for all of us to adhere to.
I like this. I'm not a fan of how number 2 is worded. I don't like that there's necessarily a limit of 30 minutes unless it's voted on by the board. I just think that if the board votes no, then everyone doesn't get a chance to speak. So I don't like that portion of it. But otherwise I don't mind it.
I tend to agree with you, Trustee Cavella, because you don't know who's going to be here, how many people. It's as long as everybody, this board or myself have been criticized for letting people talk 2 and 3 times. And, people have asked me to limit it to 1 time for 3 minutes. So I think it's in fair and transparency that we adopt a policy and post it at the entryway to our boardroom so people see it when they walk in, post it on the website, let people understand what is expected of them as a resident and proper decorum and how to address the village board, and make sure that people have an understanding of what the process is. So thank you for that. Is there any other comments on this?
I'm not a fan of limiting it to 3 minutes. I don't know how much time the 2 speakers took earlier that commented during public comment. But I want to hear everything that they want to go ahead and say. I don't want to cut them off. So I don't really want to limit their time.
I think we have to have some kind of a limit, otherwise we might be sitting there till midnight just listening to public comment. And I'm not trying to silence the community, I'm going to hear that now. But I think there has to be some kind of a limit.
Any other comments?
And I think, could there be discretion? And if you have a policy and there's only 2 people that signed in to talk, you're maybe not going to be limiting them to 3 minutes. But if you have 44 people signed in to talk, I think you need to have something like a 3-minute, because otherwise you're going to be here till 1 a.m. So I think it's just something.
And I can tell you how it works in practice, because and I think I provided you guys with the Lindenhurst sample maybe a while ago, the first time. They had just adopted a public comment policy when we first talked about it. So I gave you what they had just adopted. So they've had, I don't know, 6 months, a year or so to work with it. They had no rules before. And what they're finding is residents actually appreciate the time limits. It makes them focus, but then they also know, if they're sitting in the audience, that if there are a lot of people speaking on a matter, that they're going to get their turn. So everybody has this, everybody's treated the same. So everybody gets certain, and whether it's 3 or 5, you know, what I think Lindenhurst did 3, but, and the Attorney General has approved 3, that the idea was that everybody's going to get an opportunity, everybody's going to get their turn, but they know that things are moving along, and one person isn't coming up and speaking for 30 minutes 2 or 3 different times during public comment, which they actually were having.
Sure.
And so, you know, the meetings were going long. Other residents felt like they didn't, you know, they were kind of thrown in at hour into public comment. It's worked really well, and where there were a lot of complaints about public comment before the rules, there have been none since. So it's actually, you know, I would say everybody's going to have the exact same experience, but the people that come to the meetings actually complimented the board after a couple of meetings on how well things were going. So, and there were kind of the same concerns. We want to make sure everybody gets a chance. And the 30-minute, that you don't, I mean, that's optional. That's something that can easily, some communities do it and some don't. So these are all just kind of options. The one thing I would say is the Attorney General is pretty strong in the opinions that if you're going to limit in any way public comment, put any limits at all, that you have to have a written policy. So I do encourage you to do something. Sure. So pick whatever regulations work that have been upheld, and all of these have been tested in Attorney General opinions, and you know, whether it's 3 minutes or whatever. And to what you said, you can always loosen your regulations, but if you're going to do that, do it at the beginning of public comment.
Right.
So that everybody's under the same rules. We always want to make sure that everybody's treated the same.
Okay. Any other comments?
So I just have a question. So if we did impose, you know, a time limit, I do like, first of all, what Ellen said with, you know, if it was like a larger group of people, then we go ahead and impose a time limit. But let's say for some reason the board wanted to go ahead and adopt a 3-minute time restriction. So I'm just wondering, because I've seen this at 2 other board meetings, and I don't know, like, would the mayor then stop at 3 minutes and say, your 3 minutes is up? Because I have seen that, and then they don't get to finish speaking.
Yeah, we've done that.
Yeah. It happens a lot at the zoning hearings. They're very familiar with the time frame, and you know, sometimes it's you're nearing the end, and can you wrap it up so they can finish their sentence? Most people understand. If you have a written policy, people know how much time they have, so they can budget and plan. You can't and shouldn't just adopt 3-minute policy. You may have a meeting where you have 250 people come, and if you don't have a written policy, you can't impose time limits. So it's better to have the policy and then choose at a meeting with 2 people to say, you know, we're not necessarily going to, you know, have the clock out tonight. But if you have 100 people, then you have a written policy that lets you do that. So it can be somewhat flexible if you have a policy, not the other way around, though.
I think, excuse me, I think most times in practice, from what I've seen at previous meetings, is more so from the mayor of trying to tell people it's time to wrap it up. And not just cutting people off. Obviously, we want to try to avoid that and hear from what everyone has to say, so.
Any other comments on this? Okay.
So I heard 3 minutes, looking to heighten that a little bit. Are there other folks that had different thoughts?
I'm fine with 3.
I'm fine with 3, but I definitely want the 30 minutes out. I don't want a limit on that.
Okay.
I don't want to limit it unless we have a large group of people. So if we only have 1 or 2 people speaking, I want to be able to allow them to speak.
Okay. I'll work with the village attorney here, and we'll put something together and bring it forward for the village board to consider.
Thank you. Has anything changed department head wise in the last hour?
We had one other item here, Mayor.
Do.
Minutes.
Oh, I'm sorry. You know what? I've been writing my notes on this whole thing in the next section. Let's talk about village meeting minutes.
The final item here is I just wanted to get some feedback here and direction from the village board regarding minutes at our previous meeting here. We had tabled certain minutes, I think it was August 1st minutes, and wanted to hear if the board had any thoughts or feedback as far as how detailed the minutes should be, just so that we have somewhat of a certainty here going forward and some direction that I can provide to village staff. And then also our village clerk when she returns from medical leave.
I've been happy with the way the minutes have been being presented to us, and as trustee Kozler said at the last meeting, if there is something that a trustee wants added, they can have that added, but I think it ought to be what that trustee said and not put in things that other trustees might have said at the meeting, and then we would vote on it, whether or not we want to approve it.
So wait, I'm just trying to, I'm down here so I can't hear you. So you're okay with it only being something that the trustee wants amended only if they say it, but nothing that any of the other trustees or mayor said?
Well, I think that was one of the issues that was brought up at the last meeting, was that, I don't know, somebody was asking something to be taken out of what somebody said, and then they wanted something that somebody else said and put in there. So the one trustee is kind of making the minutes, whereas we have a clerk that's supposed to be doing the minutes for us. And we've asked her to do kind of a brief general overview of what the minutes should be. And then if anybody has a interest or a question about what the minutes are, we have the videotape that they can go back and look at and clarify what their question might be.
Sorry, but just backing up to what you said earlier, if somebody wants to make a change, you want it, I can't hear you too well down here. You just want it to be something that they said and not anybody else said, or you didn't say
Well, I mean,
that?
you can put in what you want, but like tonight, we'll vote on it, whether or not we approve it.
Okay.
I think that the issue is, and again, I brought in, again, knowing that Jennifer and Chris were not on the board at the time, but when we went to video streaming and putting everything on YouTube, we kind of came to we gave direction to our staff that said, make these condensed meeting notes, an overview, because at any point, someone can relate and go into the detail of it. It's a lot of information, a lot of going back and forth, and then it becomes, is it self-serving? Do you want something in there for a reason that somehow either makes one trustee look bad and yourself look good, or what's the rationale? I think that's where the concern is. So I just think that we've given direction as to how we wanted the meeting notes to be done, and if we want to change them, then as a board, we need to discuss that and say that's what we're going to do. But I think we need to set clear direction to the village staff so that they know what's expected of them and what should be done.
I would be in favor of just doing detailed meeting notes, only to avoid this discussion any further. I think it would just be easier on the board overall if it's just out there, it's done. Also, our official record is the minutes, right? Not the YouTube video. So I think that's another consideration we should look at. So I would be in favor of all.
Yeah, I think it's amazing how people who didn't embrace the YouTube videos are now embracing it tonight. As Trustee Kraus said, I have no issue with the way the minutes are done, and the video is there, but I have stated, if a trustee wants something in the minutes, they should be allowed to have it in there. So that hasn't been honored tonight, and on that mindset, I sort of fall back to, we need more detailed minutes. That's where I'm going.
Well, if that's the case, I think that the direction we need to go is get a court reporter in here so it's verbatim, then this back and forth, because it's
Well,
What is Robert's
it's
rules?
ridiculously burdensome for the staff to go back and forth and to
I
change these
haven't,
things.
have I brought up any changes to the minutes, Mayor?
Well, you want, trustee Cavelli wants, everything, per minute.
I've never
What
made an issue-
Maybe
an issue
what
with
Jennifer
minutes.
Weinhammer wants is different when
I
trustee
understand. that.
Cavelli wants, different from you. And so we're trying to come together with a consensus that will work well with our overpressed staff, that we're not continuously coming back with burdensome requests for our staff. We've got the people's work to be doing, and they don't want to see us arguing over minutes.
I agree. And that's what's nice about having Janice on the board now, is that she says she'll take those minutes. So I think it's a win-win. all around, I think that it will avoid some of the arguing back and forth and who gets what in the minutes and who doesn't. I just think this would solve a lot of the problems. I really do.
I think some of the things that are getting added to the minutes are very self-serving. I mean, is it really necessary? I mean, I'll be honest, I read through the additions that came out at, 11 o'clock last night before a board meeting? That's pretty, that's asking a lot. I didn't have time to go back and relook at everything and see, are those accurate, are those not accurate? And there's just a lot of it that's just very disparaging. I'm not sure what it was, I'm not sure how any of that benefits our residents, that discussion that was looked to be added.
But you
That's
could
my
have- but you
concern.
could have avoided that if those minutes were already that way. See, then you wouldn't have had to go back.
No, I disagree.
See, I disagree.
You know, we can respectfully have a disagreement on that. I just think that we're getting way too bogged down into the details, and then who decides what details get added? You know, we're only going to put the details on when it's something that makes the mayor look bad, or we're only going to put the details on when it makes someone else look good.
But then, see, that's the thing, is it takes that subjectivity out. That's what I'm trying to, I guess that's the point I'm trying to get across.
Yeah,
It
but
takes the subjectivity
I just
out
think that,
of what
I just don't
gets
think, I
added
think
and
we have a
what
lot of,
doesn't, and I'm
Let's
still
just one at a
talking.
time.
Please,
Let her finish.
okay? I think it takes the subjectivity out of, well, why did this get added, but this didn't get added? When the whole thing is in there, black and white, it happened. We were here, and like you said, you can't put the video. It's there. So why not just avoid all this?
And that's why I changed my opinion. It just is the only solution to have not court reporter minutes,
No.
but pretty much, verbatim.
Well, what trustee Weinhammer's minutes were verbatim.
I'm not,
That's
I'm not
court
bringing
You
reporter.
up
asked last time if I was going to quote something that it needed to be verbatim, so I'm just respecting what you had said from last time and doing what you had asked me to do. I just have a comment with regard to that. It said Village Administrator Reif stated he did not recall the specific content of his conversation with Mayor Koenig, what Mayor Koenig was, which, as I went through here, that's not accurate. So when you guys are saying that the minutes that I had proposed last time were accurate and now this time they're not, and you want this because you think it makes somebody look bad or somebody look good or whatever, it's self-serving, I would disagree. And I mean, even when I look back at the video, that was stated, but then he said something afterwards. He did speak with you. I don't want to argue about this type of stuff.
You continuously bring this up, so it's in an argumentative kind of way, and we've moved on since then.
Can I finish talking, please? I'm not trying to argue with anybody, but when I see something that is misstated, I'd like to correct it. And with regard to all the verbiage that I had put on here, I'm just doing what you had asked me to do from the last time because I didn't have it word for word, and I apologize for that. I'm not out to get anybody or anything like that. I know you're laughing and you think I'm out to get you or to get somebody, but I'm really not. I'm just asking questions, and I just want the things to be accurate on here.
Could we try for a couple months and see if Janice, I really don't know if Janice was the one that really, if she wants to write them, how
Well,
she
it
wants
was.
to
I mean,
write them.
when she first started, it was verbatim. I mean, it was very intense. And then we told her it's too much, back off. So she backed off. And now we're going to tell her we want more in there. So it's,
She is still adjusting here. She's learning the process. But keep in mind, she's on medical leave right now, and she hasn't been taking the minutes. Those have been being transcribed by village staff here for the last several meetings.
Can I ask when she's supposed to come back?
I don't have a date on that for certain right now.
she had said sometime in September. Something unforeseen came up. I would like to have incorporated into our minutes, either at the top or at the bottom, at the end, that a video accounting of this is available on YouTube through our website. And if you so choose, you need an audio, we can always provide an audio, just so everybody has an understanding that we can get everything you want is there. We just need to just move on from this and get something that everybody can agree
Do we back
with.
up those video minutes?
The videos,
Yeah, do you record them?
they're
If something were to happen with YouTube?
on YouTube. I will have to check and see if there's another recording somewhere.
I mean, at the last meeting, Attorney Simon did say that the official record of the meeting is the minutes that we approve or don't approve. You guys didn't approve them this time. That's fine. I don't agree with it, but it's the board's decision. So I would like to be able to go ahead and make amendments in the future if I want to. You guys can always vote on yes or no, but
what the statute requires.
And
Okay.
Chris
What
is
is
like,
the
I gotta
yeah,
let-
what's
I
the
gotta-
statute
trial
required?
period?
She just,
Yeah, that's what I was gonna, because I brought the statute. It's very bare bones. It's the Open Meetings Act, which we all know governs what we have to do as meetings. And there's language in here about what has to go in minutes. And it's pretty minimal. It's the date, time, and place of the meeting, the members that are present, if they're participating physically or present by video or audio, so if they're electronically participating. And then a summary of discussion on all matters proposed, deliberated, or decided, and a record of any votes. And that's it. And so when it talks about a summary of the discussion, it specifically means those items that are listed on the agenda for action. So whether you vote on them or not, it's an action item, and that's how it's been interpreted. The Illinois Municipal League has made recommendations on minutes, that they should not be a verbatim account of everything said during the meeting. They should only provide an adequate record of official action. That's the official record is what you did at the meeting, not what you said. It may be a summary of the discussion before you vote, because a trustee may want to make sure that the minutes state why they're voting no or why they're voting yes. And in that case, that's a summary of the discussion leading up to the vote, and then, of course, the actual vote. But the Municipal League also says that speeches, discussions, or statements should not be copied into the minutes. Now, these are that's the Municipal League, so that isn't law. Law says you have to have these 3 things in your minutes. Anything else that you decide to put in your minutes is up to you. But the important issues are to have who's present, how people voted, and a summary of the discussion on the matter that's being voted on. So those are the important. So once you meet that, you've taken care of complying with state law. How far you go beyond that, I've seen minutes that in some communities, most communities are pretty bare bones. Some communities do have very detailed minutes. That's a board decision. So it's the direction from the board. Just like it's your minutes, it's the board acting who approves the minutes. It's your decision on how much detail goes into them.
I will say that it does take pretty significant time from village staff to do detailed minutes. But with that said, I mean, we're here to work for the village board, and it's up to the village board to decide what you want your minutes to be, so.
And again, it's going to be a limited time that village staff would be doing that because we actually have a clerk that is coming back.
I hope so, yeah.
but after she does the minutes, the staff goes through and edits, makes sure that everything's correct, and then they produce them for us to review. So there is staff time still advised, and she'll do the comprehensive minutes. I'd say, let her know what we're looking for, and see how she comes back with it, and we can tweak it moving on. But this is something that we've spent way too much talking about.
We've had
Needs
to,
move on.
we've had to add some things after they've been completed by the village clerk, yes.
So it's a learning
So
curve.
you said we go ahead and look it over. So do you look over the board minutes then before we see them?
I get them when you get them.
Okay, I didn't
The
know
only
that you
thing I
said
see
we, so I was just
beforehand,
asking.
the only thing I see beforehand is when Jake sends out the agenda beforehand, I get a copy of it in my mailbox. That's the only thing I get before you guys. I don't get anything else. Any other comments on minutes?
What did we decide? Are we gonna,
That's what I'm kind of looking for.
yeah,
I'm looking forward to give Janice an opportunity to come up with a hybrid of what we're looking for so that it can be more accurate, because it doesn't do us any good to implement something that she's not here to say, okay, this is what I can do, this is how I can permit it, this is how we can get it done.
okay. We did have 3 people interview for that position. So I'm hoping that whatever the board decides, she would be comfortable with it.
That's fine, thank you.
So in the time being, I mean, does the village board want us to continue with kind of the path that we've been down here? I mean, I guess I'm just a little bit unclear of what.
I would say in the time being right now that she is on medical leave, that let the staff do a condensed version because they have their own stuff to do. And when Janice gets back, let's talk to her and see what if she is wanting to do the full minutes and go from there.
I just don't know. I know that this is a new board, and that's the direction this is going. We had, the old board decided to have abbreviated minutes, and that was good. I was fine with that. I've never brought up any issue with minutes ever. So it's not my thing, but we have a new board. And now the new board is saying abbreviated minutes aren't good enough. At least that's sort of what I'm hearing. Not everybody, but it seems like that's sort of the consensus. So I think they have to be more detailed. I'm not saying it has to be verbatim, but let's get a little more detailed. And that way it's in black and white. And
Right, well, why don't we just do a little head count here then?
Yeah.
You want you want the minutes, kind of what they were before, but a little bit more beefy. That's what you're asking.
yeah, I guess, yeah.
Trustee McAlpine?
I want abbreviated.
Trustee Kraus?
I'm happy with the abbreviated, but I think the climate that we're in right now, we need to go with a little more detailed minutes.
I'm happy right now because of staff to be abbreviated.
I agree with trustee Kostler and Kraus. I like it a little bit more detailed.
We know who you are. I'll agree, a little bit more detailed is fine. I totally can work with that.
Very good, thank you.
Any department head? Great. All right, I'll entertain a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
Opposed? Thank you.
You crew.